Hi, everyone. Welcome on this very hot day. Feels nice in here. My name is Ellie. I am part of the 92nd Street Y Talks team. Welcome to 92NY's 150th anniversary season, as well as to our newly renovated Button-Weiser Hall at the Arnhold Center. It is my absolute pleasure to present tonight's event, Law of the Land, Supreme Court Year in Review, alongside Folks, the Forum on Life, Culture, and Society, an organization we have collaborated with for over 20 years. This program is also part of the Newmark Civic Life series and is brought to you through a generous gift from Craig Newmark Philanthropies. Tonight, we will break down this year's major and highly contentious Supreme Court rulings with our panel of experts. Before we get started, please note that we will have time for audience questions near the end of the talk, which our ushers are distributing, so please grab a card. If viewing on the live stream, please submit them in the chat. If you are here for CLE credit, there is a table in the lobby to sign off, so please do that, and we will be giving you some codes throughout, so make sure you jot those down. With that, please give it up for our wonderful, wonderful panel.
Good evening, everyone. I'm Thane Rosenbaum. I'm the creative director of the Forum on Life, Culture, and Society at Touro University, and welcome to Law of the Land. This is, for folks, one of our fan favorites every year, even during the pandemic, and we're back at the 92nd Street Y. Last year, we had it here before Butt Hall got renovated, which is awesome. And this has always been a fan favorite. You know, folks, we have film series, conversation series, idea series, book series. We have the film festival, and yet Law of the Land. It's every year, all last week, people were calling me with questions. Conspiracy theories, I'm not gonna share them with you. It's sort of a homecoming. Every year we do it. This is like the 8th or 9th year that we've done it here. It's like a rotating cast. Some people are sort of permanent members. This is sort of the A team, and it's a homecoming of sorts. Bill Traynor, to my right, is the dean at Georgetown Law School. He's also you don't even know why you're applauding yet. I'm going to tell you now. You all jumped it because you're Georgetown people. But I was going to give you the real reason. The real reason is Folks was created 20 years ago by Dean Traynor when he was at Fordham Law School. and yeah, it's true. He's done some good things at Georgetown, but this is still the best thing you've ever done.
Oh, absolutely. Except for my marriage.
This and Allison and the children and Thane are. Bill is also one of the leading constitutional law scholars on legal theory and legal history, so he's perfect for this, and so we always welcome Bill back. We have with us Adam Liptak from the New York Times. He is, Adam, you know, is long-time serving Supreme Court correspondent, covers this beat every single day. Before that, he was the national affairs legalist correspondent for the New York Times. And I have a little anecdote for you. The very first event that we did back in 2007, it was an event with Tony Kushner and E.L. Doctorow. And we talked about why artists are obsessed with the Rosenbergs, the Rosenberg trial, the Rosenberg execution. And so we brought in, remember Tony Kushner wrote Angels in America, which Ethel Rosenberg is a character, and E.L. Doctorow wrote the Book of Daniel, which is a novel about the Rosenbergs. Adam Liptak covered that for the New York Times, and it made the front page of the art section. That's how we started out. And this guy, I don't know if he remembers it, he and I were high-fiving in the hallway the whole day, the next day. That was the coolest thing. So anyway, Adam, we love you. Thank you.
Happy to help.
And Adam has been a guest of Folks many, many different times, and he's been returned even not in other programs, but certainly for Law of the Land. We have Dahlia Lithwick with us. Dahlia Lithwick, yes. Dahlia is, what can I say? She too has been with us from the very first of the Law of the Lands. We were reminded even before there was a Law of the Land, we did another kind of event with legal journalists, with Adam and Dahlia and some others. Dahlia is a senior editor at Slate. You see her on MSNBC covering the courts and legal affairs. She's the author of a new best-selling book that's been out about a year, and I know this because we featured the book, Lady Justice, on one of our Folks events. She was amazing in it, so you should go to folks.org and you can watch Dahlia, and you should also buy the book. Dahlia Lithwick. Tiffany Graham is with us. Tiffany Graham is a constitutional law scholar at Touro Law Center, and she and I are colleagues, and we have her every year. She's the one constant. So Tiffany, great, thanks for coming back. And lastly, someone who's new to our stage, Rod Rosenstein. You may remember Rod was the Deputy Attorney General in the Trump administration. He oversaw the Mueller investigation in the Russian meddling in the 2016 election. There's some interesting anecdotes about Rod. In addition to being a long-term career public servant in the Justice Department, he was for 12 years U.S. Attorney in Maryland. And ready for this? For the entire 8 years of the Obama administration, he was the U.S. Attorney in Maryland. He was the only person that Barack Obama did not ask for his resignation. He stayed on. Obama said, you know what, I want this guy. So he stayed for the entire 8 years. He's the only one that I know that Obama did that with. Now, I'm going to give some moment just to let this settle in for a second. He's a Republican.
Sorry.
Now, I know this is Manhattan. Donald Trump is profoundly unpopular. I don't think he liked Trump either, so you should know that. I know this is 92nd Street Y, but just give him a chance. Just give him a chance. Show some decency. And Rod, let me tell you something, buddy.
You didn't tell me I was going to be heckled here.
Let me tell you something, buddy. You pull any Republican shit on this stage, Kevin Green is our security head here. He's built like a mountain. He will have you on the Acela in minutes.
I've been forewarned.
All right. Before we get to some of the cases, I thought there's so many cool things, preliminary things to talk about. For instance, and I want to start with Adam Liptak on this, and we all jump in, it's a free-for-all. We still don't know who leaked Dobbs. And I just don't understand how that's possible. We're talking about, 50, 60 people are possible candidates. They're not that athletic, They're law clerks and judges. They're not that agile. I don't see how we don't know this. And Adam, you don't have like a deep throat at the New York Times? Nothing like that? No inside person? How is it possible that we still don't know and we probably won't know?
Well, I can't talk about my sources. When national security matters are leaked, and you get serious professionals trying to run down those leaks, they very often come up dry. And if you put the Supreme Court marshal on the case, who doesn't have any particular forensic skills, you're likely to get the same result.
I was going to ask Rod about this, because I read that very point. Whoever's phone that is, please stop that. Seriously, please, don't you know this is not the place for that? Rod, I read and I didn't understand it. There must be some protocol that the marshal's office does this and not the FBI. Now, I remember The Fugitive with, Harrison Ford. That was cool, but I don't think of them as investigators. Why, when you were at the Justice Department, could you have called Chief Justice Roberts and said, buddy, we investigate for a living. The FBI, let the marshals do what the marshals do. Let me in on this.
I think the FBI has enough on its hands. The challenge would be saying that the FBI investigates crimes. It's not clear this was a crime, and so it wouldn't necessarily fall in the FBI's jurisdiction.
I see. So is that the point, that last point that Adam made, is that a point that makes sense to you, that you wouldn't expect, marshals don't do this for a living, so you
Right.
can imagine that this is not something they might come up with so quickly?
True, although I also would point out, Adam mentioned national security cases, finding leakers is a lot harder than it sounds. And if you think about a scenario like this where somebody might have taken a hard copy, so there's no electronic trail, and handed it to one reporter, you only have 2 witnesses. And so it can be pretty challenging to solve that kind of a case.
Last year, Tiffany, we started with you and ended with you because of the newly appointed Justice Ketanji Brown Jackson. And you may not remember this, but we all remember, which is you went all fangirl on us, right? You were upset that you didn't make it to the Harvard reunion. You wanted a photo with her. You were jealous that it was on Facebook. You weren't on it. You know, and that was cool, because like that was like trading baseball cards. Like that this was your. How was her rookie season?
Amazing. I just think that when you look at the way that she really just attacked the court and attacked the job this year, you can tell that, number one, she really had so much comfort. She jumped into the questioning during oral argument. She did something that people didn't expect. She jumped into originalist inquiry. And then she also wrote single dissents. You know, you compare that to John Roberts, and I read today that it took him 16 years to write a single dissent, and she did it in her first term. So, I mean, this is someone who's extraordinarily smart, extraordinarily confident. She's a boss. I mean, I just love her.
So I want to talk to Adam and Dahlia about this, because it cuts to something that I know Adam had mentioned once in one of the Law of the Lands. Most people don't realize, right, that up until very recently, you could, like Justice Thomas, go decades and never ask one question, and that's okay. That there are some justices that jump in early, and some justices just don't ask any questions. And it's because of the pandemic, right, Adam? I think you explained it. Maybe you could briefly explain. The pandemic changed the rules, and it actually forced out some people who might not have spoken. I don't know if that's what explains this. I think I have a different idea about what explains with Judge Jackson. But tell the audience.
So during the pandemic, 2 things happened, both of them very revolutionary at the court. One, they initially heard arguments by telephone, and they had to give up their usual free-for-all format where people are jostling and trying to get their questions in. And they went to a one-by-one seniority system set of questions. And that, among other things, had the effect of getting Justice Thomas, who hadn't talked for a long time and very rarely, to start asking questions. And I think everyone agrees that's a good thing. Then when they come back from the pandemic, they like this well enough that they're going to have both their free-for-all format and then the one-by-one. That has the incidental effect of making the arguments preposterously long. And the affirmative action arguments lasted for like 5 hours plus, and you can ask questions about that. But getting everybody in the mix is a good thing. The junior justice is especially apt to try to talk during arguments because it might be her only chance to influence the other justices, because when they go to their private conferences, they speak and vote in order of seniority, and by the time it gets around to Justice Jackson, it may be that her points are pointless because everyone has already dug in. So it makes sense to try to raise your points at argument. People have the misimpression that Supreme Court arguments are an attempt to elicit information from lawyers. Not true. It's an attempt to talk to your colleagues and make points. It's the first time they've discussed a case. And as Tiffany says, Justice Jackson, unlike other justices who say they will sometimes spend years trying to find their feet, on her second day of argument, she was making very pointed, originalist, progressive arguments about the 14th Amendment.
So, Dahlia, you wrote Lady Justice. This is not in your book, but it's the perfect segue here. I wonder whether you have something to say about the fact that it was also true of Sonia Sotomayor, that it was noteworthy that she too early on jumped in. And I remember there were some stories about, well, who is this person? And I remember, by the way, nice little anecdote, that day that you covered the E.L. Doctorow thing with Tony Kushner, you know who was in the audience that day? You don't know this, Sotomayor. No one knew who she was. And you didn't know she was there either. I found out later, someone said, how do you know Justice Sotomayor? A judge, at the time, she was just a federal judge here in New York. And she was there, and I said, wow, that woman decided to come out to hear Tony Kushner and E.L. Doctorow talk about the Rosenbergs. That was what she did that night. And guess what? A year later, she was on our stage. But it just shows you the little 6 degrees of separation. But I will say this, when I had her on this stage, I said to her, I said, there's some people that wondered, you jumped in really early and you started, jumping. I didn't want to offend her. And she said, to your audience right here at the 92nd Y, she says, I'm a Puerto Rican girl from the Bronx. You think I'm not going to talk in a room? It got a big laugh, by the way. But do you think that there might be something to be said about women power on the court, that we have our turn and we're not waiting for our turn?
I think just a third data point is that the other person who got a bad rap for talking too much too often when she came on the court was Justice Ginsburg, who was also accused initially of being way too forward and presumptuous.
Now, do you think this is a double standard, or do you think that men didn't do this?
Yes, it's a double standard. And also, I think there's something profound that happens when this sort of goes to what Adam was saying, that you're going to be on the losing side of a case before it starts. Because the other thing that happened in COVID is that people could listen in real time to oral arguments. We didn't have that. We had same-day audio, I think tragically, on 2 or 3 cases a year, and that was determined by the Chief Justice. And for people to be able to listen in, to sit in their cars and listen to C-SPAN, what was phenomenal, and this goes to Tiffany's point, was that in her first week out the chute, we had Justice Jackson pretty much understanding not just this is my only time to influence my colleagues, it's actually the only time to talk to future lawyers and law students and young people about the original public meaning of the Reconstruction Amendments. And so I think that there's something very, very important about having audio. And I think that some of what we're seeing now is the justices realizing if I'm going to be on the losing side of this case, I'm not waiting until the last day of June to write my dissent. I'm going to put these ideas into the public bloodstream so that folks can, and that really happened, I think.
And to your point about influencing things, I think that the story that she told during the affirmative action case about the white kid who was a 7th generation North Carolinian and the black kid who was a 6th generation North Carolinian, and the role that race may have played in both of their lives. And why can't UNC take account of race, given the fact that the lack of opportunities for the black kid obviously impacted his family's inability to go, whereas discrimination helped the white kid? That may very well have impacted John Roberts' the little crack that he created in the majority opinion, where he said, students still have the opportunity to talk about the role that race has played.
You mean like in an essay?
Yes.
In an essay.
That may very well have been her influence just by bringing that up in oral argument.
Rod, ethics inquiries. I don't know whether this ever, in your mind, would have been something that's a Justice Department. I think it's important to raise questions about the 3 branches of government. We have a legal historian on our stage. Justice Roberts chose not to testify in Congress. He was asked to speak. I didn't expect that he would. Who's in charge? The Supreme Court only recently is abiding to a new set of rules. When Justice Thomas says, I'm just doing what people did when I got here. When I got here, I asked people, if someone invites you to a vacation, do I have to report that? And he's saying, they told me not. I was associate justice, and I did what they told me. How does this play out? The Justice Department would never be called into this, right?
Well, potentially, not for the kind of allegations that have been in the media recently. And there are really 3 issues here. The first is, can you accept a gift? The second is, do you have to report or disclose the gift? And the third is, having taken a gift, do you need to recuse from the case? And those issues often get conflated, but they're really 3 distinct questions that are raised. And there haven't been any issues with regard to
who decides recusal? How does that, what's the standard?
Well, the recusal standard for the Supreme Court is actually left to their discretion. And that's one of the issues that has been the subject of some discussion. And there are really good reasons for that. There are good reasons for the threshold for recusal to be high on the Supreme Court, because you think about what strategically could be done if Supreme Court justices routinely recused. For example, Ruth Ginsburg had a husband who was with a major law firm. And if her policy had been to recuse every time her husband's law firm had a case before her, clients would have strategically chosen that firm in order to bounce Justice Ginsburg off the case. So,
Wow.
so there are reasons for the court to have a high threshold, but the short answer is that decision about whether to recuse from a case is left to the Supreme Court justices with no oversight and no enforcement.
So, Bill, I don't know if you want to jump in here. From a historian standpoint, I was thinking about this in connection with an essay I just wrote. I had forgotten that Abe Fortas, who was appointed by President Johnson, and in fact, after he was an Associate Justice, Johnson wanted to appoint him as Chief Justice. Apparently, he was a major advisor throughout the entire Johnson administration. And I think for this room, Fortas should be remembered for two other reasons. One, this is the YMHA. He was Jewish, and more importantly, way more importantly, he was a great violinist. And would have, apparently, did you know this? Every Monday night, in all of his years, did you know this? There's great, every Monday night he played in a chamber orchestra of high quality musicians every Monday night. And so downstairs, he could have played at the Kaufman Auditorium. He was forced to resign, asked to resign for financial impropriety during the Nixon administration, for not a gift, but accepting a payment. I don't even understand what that was. Was he given a speaker's fee? What was it that he ended up on, I assume that was a situation where the Justice Department in the Nixon administration was involved. I don't even understand how this happens. Who gives them the talk? It's time for you to leave.
that a question for a historian?
Well, yeah, Bill, do you have anything?
Yeah, I have to say, I don't remember. My
Fortas.
memory is, so I think there are two things, right?
Mm-hmm.
So Johnson nominates Fortas for the Chief Justiceship, right? And they're very close. And as a matter of fact, Johnson kind of pushed Arthur Goldberg off of the court so that he could give Abe Fortas, who was like his big buddy, the seat. And he said,
By the way, the Jewish seat on the Supreme Court, Arthur Goldberg left to become the ambassador to the United Nations,
Right.
and was replaced by a buddy of the president.
yeah, I mean, he was brilliant. Fortas was really an extraordinary lawyer.
He was a Yale law professor.
He was a Yale law professor. He was a leading
Yeah.
D.C. practitioner. Just incredibly revered as a lawyer. But he was also very close to Johnson, and I think actually argued. I think the '48 election where landslide Johnson, he kind of snuck into the Senate by kind of illegal ballots, and by 80. I think Abe Fortas was
And
his
he
lawyer.
got
in
Justice
that.
Black to enjoin the vote count.
Yeah.
I got another anecdote. Thanks for reminding me. Great anecdote. He argued Gideon versus Wainwright.
Right. So he argued Gideon. So he really was a legend.
Yeah.
Very close to Johnson. Many, many years.
But Gideon versus Wainwright, right to counsel. Just most of the room is civilian. For those who are not civilians, it's time to tell you something. Hold on, Bill.
Okay.
The first CLE code right now. We're playing bingo here at Budweiser Hall. 92NY8. If you're online now and you've got to tell them. And if you're here on your phone, 92NY8 keeps you in the running for your CLE credit. Go ahead, Bill.
As a former member of the New York CLE board, make sure you get those letters right. So Warren announces he's going to retire. Johnson pushes forward, nominates Fortas, but it's very controversial, and that's actually an example of kind of a late nomination that's blocked in the Senate.
Because it was like a filibuster or something.
Yeah, and Homer Thornberry was actually another Johnson crony he was going to name to the court. And then, Nixon comes in, and then the investigation of, and I think.
So they didn't actually investigate him during the Johnson
I think
administration.
it was during the Nixon administration.
okay.
if I'm not-
It's actually an amazing story because Nixon actually wants him out. And Nixon dispatches his Justice Department to go and visit Warren, so that there's actually like a car that pulls up to the Supreme Court, and they're saying, here's the dossier, here's what's going to happen. And Warren is so alarmed by what he thinks are these, and just it's a lectureship he accepts,
Yeah.
right? It's like kind
Yeah.
of, it's not the
Wait, so
glacier.
that's what it was?
It was a sponsored lectureship.
$20,000.
I don't know how much.
No, that's what it was.
It was $20,000, but $20,000 was a lot more.
No, no, I understand.
Yeah.
But
it's not.
it wasn't.
It's not a.
Not- it's,
Right,
it's
and it
not
was
like
also-
Harlan
There's
Crow
nothing
money.
illegal about it,
No, but it
right?
was also somebody who'd been subject to securities
it was-
Yeah.
violations,
yes.
right? So it was not just
Right,
a
It wa-
random
it was
person.
somebody that the SEC had gone after. But it's Warren who says, right, this is his friend, and he gets the court together, and they push him out.
Wow.
And so the analog today, in some sense, would be the Chief Justice
Would have to have a sit down.
saying, we're all sitting here together, this is bad for the court. So it's Warren who did it.
Right. But, you know, think about what a difference that makes. You know, I mean, that would have been a Democratic seat, and it became a Republican seat, right?
Yeah.
And, you know, and Fortas didn't have to go. I don't think he would have been prosecuted. You know, he was just kind of pushed out the door, and that really, you know, think about all the 5-4 decisions. That's a big deal.
Yeah. The question is, do we live in a different time? We shouldn't spend talking about this, but I'm just curious. Do we live in a different time in the age of social media where everyone is, you know, even Supreme Court justices, we seem to know nowadays in the age of the notorious RBG, we tend to now even know what they look like. By the way, I remember when we did that first event back in 2007-8, I remember one of the things we talked about was no one knew what any of them looked like. And looks a very big difference from 2007 to 2023 that now we actually do think we know them. I wonder whether Thomas would say, I'm not going anywhere. I'm sorry, I'm not going anywhere. Or Alito would go, thank you very much, but I'm not giving this up.
Why would they not? Why would they go?
Right, but I'm saying Fortas didn't have to go,
Right.
and he did.
No, I mean, it's a very different time.
Yeah, I'm just saying that you can imagine there was a certain sort of sense of respect of the institution that might have said to Ford, I'm not fighting about this. If you want me to go, I'll go.
Yeah, I mean, Nixon would not have, you know, today, Nixon would have burned the tapes.
Right, exactly. All right, good point.
Can
I
I,
like that.
can I just
Yeah.
say one other thing? I think what you're saying braids so beautifully into these questions about the legitimacy of the court, which is sort of the way the term started, right, with Justice Kagan and Justice Roberts sort of taking extracurricular potshots at one another about how whether it's proper to talk about the legitimacy of the court. And actually, you know, that's how the term ends in some case, in some sense, because that's in the debt forgiveness, that's the majority in the dissent. Same two players taking potshots.
Where they're essentially saying, don't think we hate each other.
Well, and also that the legitimacy of the court is our business and it's not
Right.
for the children. And I
In
just
fact,
think...
I'm sorry, one of your articles, I think you talked about this, one of the people you interviewed said arrogance. A certain level, one of the people I think you interviewed for one of your articles
Yes.
talked about that it comes across as a kind of arrogance.
Yes, but I just think like I would connect that back to, you know, sort of Bill's point about how it's different now, is
Yeah.
that there is no question in my mind that when the justices sat down with Abe Fortas and said, you are hurting this court, that fell on very different ears, whereas today, when you have Justice Kagan saying, you know, or even the Dobbs dissent saying, we are hurting this court, right? What Sotomayor calls the stench, like it or not like
Yeah,
it,
yeah.
that's met with, I don't care.
So to make the point at a slightly more general level, there used to be this idea that ethics was a neutral principle that applies to everyone equally. And now ethics itself is a politically polarized issue.
I see. Well, it goes to, that's right. That is a great point, and it leads beautifully to this question, which is the polling numbers have never been lower. I think I just read NBC poll, 40% of Americans have a negative opinion of the court, and 53%, an ABC poll, 53% say that they believe that the decisions are strictly on partisan lines, right? So those,
Well, they're wrong.
the,
I mean, what people don't recognize is the large degree of unanimity on the court. Of the 58 opinions issued this year, 50% of them were actually unanimous, 9-0. 88% of the opinions included at least one of the liberal justices in the majority. So only 12% of the cases, which is a total of 7 cases this term, were all 3 liberal justices in the dissent. So you know, the reality is, if you look at the big picture, the court is not as fractured as it might
but
appear.
they may not be, the public may be wrong, and we'll talk a little about this. Adam actually wrote about this really well last week, and so I want to come back to it. about this idea of, like, you know, if you do the numbers, what Rob just said. But you know, the question is, does the court care what the public thinks? I know that you've said over the years that Roberts is an institutionalist, right? And he believes strongly in preserving the integrity of it. But do you think that they care? Do you think that they read the page, like the sports page, and say, wow, they don't like us today. That's terrible. We got to do something to fix our...
Right, but I would say two things. You know, on the big controversial issues, they line up politically. You know, this is not the way it always was. You know, I mean, I think if you look in the Warren Court, you know, there are people you wouldn't know. How was Harlan going to come out? How was Black going to come out? How was Stewart going to come out?
You mean it was much more ambiguity?
It was much more ambiguity. You know, it has become a time in which, you know, for a while it was how is O'Connor going to come out or how is Kennedy coming out? So, you know, but, you know, 40 years ago, there was an incredible amount of indeterminacy. Whereas now, on the big issues, they line up. Now, the one thing that, you know, that I would say that, for me, that's different from this term than last term is, the last term was just like all hard right.
Yeah.
Right? I mean, every big case, right? And, you know, 2 years ago, you know, when we were looking at the term, we thought, you know, it looks like there may be kind of three groups on the court. You know, there's the left, there's the right, and then the moderate conservatives, right? Which would be, you know, the chief and Coney Barrett and Kavanaugh, right? Last year it looked like no.
Right.
You know, it's like 6 against 3, 6 against 3. But this year, it looks to me like it's much more 3, 3, and 3.
But isn't that huge?
That's huge. That's huge.
I mean, I think that's what Rod, in some ways, because I want to come back to that, because I think that for all the talk, it doesn't end, and we'll talk about this, it doesn't end great, you know, the last 3 decisions on 6-3. But if you really look deeper into this, there are a lot of surprising votes. Like, who knew, this is going to get a rise out of these people, who knew that Roberts is a liberal? Like, you're going, what are you, crazy? I'm saying, he votes 90% of the time with the majority decision, right? He's always in the money. He's 90% of the time, he's in there.
I think it was 95 this year.
Is it 95? I'm saying, I know you're saying he's not, of course he's not a liberal, but let me just say this. The 3 Trump appointees are nowhere near as conservative as Alito and Thomas. They're liberals compared to them.
But the court is 6-3 conservative. Of course he's almost always in the majority. That's math.
But he votes. I mean, Adam, you should jump in, because that article of yours really does a really good
Let me refine your
job.
point, and then Dahlia will tell you the truth.
I'm just like,
I said it was going to get a rise.
So it's absolutely true that in a handful of cases, the liberals prevailed, and not in trivial cases. The Voting Rights Act, the Indian Child Welfare Act, the Biden administration's program to set priorities for immigration,
Yeah,
the independent state legislature doctrine. All of those cases were wins for the liberals, but wins in a narrow sense because nothing got worse. They weren't wins in the sense of moving the court to the left. So it's a much better story from a liberal perspective than the last term, but it's still not, isn't this great?
Right, so-
the way I put it is not getting punched in the face is not a win. And like every one of the cases that Adam just listed, right? And this goes to Professor Steve Vladeck, if you haven't read his great book, The Shadow Docket. The way he says you can't run the numbers exactly the way Rod runs them, because there's not a one-to-one correlation between some trivial jurisdictional case and overturning affirmative action for the first time in 50 years, right? So we have huge cases and we have little cases, and this is important, the court has discretionary jurisdiction. The court picks its cases, so that whole data set is self-selected, right? Those are not cases that the court had to hear, and of the ones Adam listed, I think the only one they had to hear was Allen, right? Was the
voting rights case. But let's
And
pause up for a second on that case. So there's John Roberts, who has done nothing for voting rights in his entire career, writing the majority opinion in a case that may well deliver the House to Democrats. So you can't minimize it.
We're talking about the North Carolina case.
No,
The Alabama.
the
We're talking
Alabama
about, just to be clear,
gerrymander.
we're talking about this voting rights case.
Right,
So-
and you know, somebody who's always said race is irrelevant, to actually say race is relevant in this case. I mean, I was stunned by
And
that.
to follow precedent when he didn't have to. I mean, Alabama teed that up to alter the law and offer up a race-neutral interpretation of Section 2 of the Voting Rights Act, and he could have chosen to do that, and he didn't do it. So I absolutely commend him for doing that. I will also say, to your point about picking their cases, another angle with respect to picking their cases is picking the cases where they really shouldn't have chosen the cases. By way of example, the student loan case, where there's no standing. Who's injured in that case? Certainly not the state of Missouri, but they found an injury that didn't exist. So, I mean, this is, again, like Rod, I respectfully disagree with you, because again, it's about the quality of the cases where it's the controversial cases where you see the 6-3 decisions where you see the real controversy.
So wait, it sounds like, Tiffany, what you're saying is, over the last 2 years, if you talk about Dobbs and the New York gun case and the EPA case with the Clean Air Act, and then this year with the affirmative action case and the student loan forgiveness case and the Colorado case with the gay wedding website designer, you're saying, if you're 6-3 there, the hell with the rest of the stuff, right? Because this is so huge that nothing you can do in these small other cases. Might be interesting that you voted with liberals, but those 6 cases over the last 2 years are so monumental that we're not going to let Thane Rosenbaum say, he's a liberal.
I don't want to say to hell with the rest of the stuff, because that's not fair. It matters that in Allen versus Milligan, the Alabama voting rights case, that Roberts in fact may have delivered the House to Democrats, because we've got cases coming out of Georgia and Louisiana and Texas that are going to be impacted. But I will say, as far as those big cases are concerned, I mean, Linda Greenhouse writes her article the other day where she points out very systematically the way that the Roberts Court has delivered on Republican priorities carefully and systematically for the course of his time as chief. And I know that it's rather cynical to think of it that way. I mean, you want to think about the court in an elegant and sophisticated way, but just from the standpoint of brass tacks, the things, especially in the past couple of years since we've gotten to the 6-3 lineup, the priorities that have been delivered by this court are extraordinary. The way the constitutional law has changed, the way I have to change my notes every year, it's really tedious and it's hard.
So I want to get to that in a second, and maybe Bill, you might want to jump in and to say what the 333 means to you and why you might maybe not agree entirely with Rod, but understand that something of significance has happened. Just to keep everyone up to speed, just so you remember, the Alabama case is a voting rights case in which you have a gerrymandered district, a redrawn map that somehow left out African Americans, that they would only get 1 seat. And the Voting Rights Act had been established essentially to protect against this kind of racial gerrymandering. It just so happens that over the last 4 or 5 years, when we've done law of the land, we've seen the court chip away at the Voting Rights Act. Little things that drive law professors nuts, small things. So that's what I think Tiffany is really saying, that this was very surprising that he would stand up for Section 2 of the Voting Rights Act, because in the prior bunch of cases, you saw the court chipping away. Let me just quickly then also explain something else Tiffany said a moment ago, when she said about standing on the student forgiveness case, the debt forgiveness. The reason the question is, when $400 billion don't go back to the federal government, right? That's the money that's owed by these student loans. $400 billion, that's a lot of money. The problem is, the people who brought the case are states. They don't get that money. It's not their money to complain about. So why are you here? That's when she said, standing, right? She goes, why would the case be even heard in the Supreme Court unless there was some kind of an agenda? Because it's not normally, it's not the case you would see. And then ending, and I want to leave it to you now, what you left us with at the end is this question that I think people who are taking CLE credit are curious about, which is, you're the longest serving dean in the United States. I thought the Supreme Court makes decisions incrementally. Like, I didn't know that all of a sudden in the last 2 years, you're seeing these sweeping overturning of cases. We're not used to that, right? Isn't that what really is going on? Gigantic shifts in the law that force law professors to have to redo their notes, because normally we are told the justices like to do very narrow incremental changes. And now it just seems like, hold on to your hats, the last day of June is going to just knock you over, and that has happened the last 2 years in a row.
Well, but I mean, I think it's more last year that's totally the case, right? I mean, every case was the hard right case. Now, I mean, I don't think Roberts is a liberal, and I don't think he's a moderate, but he is an institutionalist, right? So if you think about Dobbs, right, he would have preferred that you chip away at Roe rather than just level.
And he was trying to lure Kavanaugh.
And he was, right. I mean, I think, when we talk about what happened with the leak, I mean, it seems to me that was to freeze Kavanaugh. Kavanaugh could have
But you're saying it's a conservative leak.
I
You
didn't
think
say
that's
that. I
no,
was just saying
you're
it's
saying
to
that's a
freeze
way of seeing it.
No, I mean, it seems to me that the only logical reason that I can think of for doing that is to freeze Kavanaugh. That he would look weak if he flipped, right? So I have no idea who did the leak, but that's the only, I can't think of a liberal reason to leak. I can't.
I think I've said, and I think I agree with your theory, but there are other theories. One of them, one is a counter theory. Alito says, why in the world would we have leaked? It wouldn't become law until actually issued. And in the meantime, all you need to do is assassinate one of us, and it doesn't become law. And you go, well, that sounds a little crazy. But in fact, someone did turn up at Brett Kavanaugh's house with the idea of murdering him. So that's one counter argument. The other counter argument is that abortion turned out to be great for Democrats in the election. And this gave them a 6-week head start on that.
Yeah, I don't think the Democrats realized how great it would be for them. I mean, that was remarkable, but I would not have guessed that it would be so powerful. Tiffany?
I will say, okay, I have 2 thoughts on that about the way that this term turned out. One, affirmative action is not Dobbs. People do not feel about affirmative action the way that they feel about abortion.
Polling even says that.
That's right. But I think it's worth pointing out that Roberts did what Roberts does. He did not overturn Bakke and Grutter. Instead, he just said that the use of race in affirmative action in this way is unconstitutional. So he was we all know what happened. He just was very careful about the way that he did it. And I think that he kind of learned, I think the court learned its lesson last year after Dobbs. So, and I'll say something else too. We've got a really interesting case coming up next year, the felon in possession case in an election year. It'll be interesting to see what happens
Right,
next
we have
year with
another
that.
gun case coming up next year. Maybe we'll talk about, if we have time, which I doubt it. Dahlia, you have?
I want Rod to talk.
Yeah, Rod.
What about?
Rod, I wanted to, this next question was for you.
Okay.
This was,
I just feel like
To follow up on that point, though, I think that I agree with Bill.
Dahlia.
These are
You're
incremental
awesome.
decisions. They're not as dramatic. They're not necessarily as dramatic as has been portrayed. The affirmative action case, for example, puts the country in the same posture as the state of California. It doesn't mean race won't be irrelevant to admission decisions. It just means decisions can't be premised solely on race without considering other factors. So I think that I do agree with Bill. I don't think these are as dramatic as they're made out to be.
Now I would like to respond to Rod.
Rod, so one last question before we get actually into some
No,
of
I
these.
would really like to respond to
Wait,
what he
oh,
just
you
said.
do? You do? I'm sorry.
Yes.
Oh, yes, of course.
Just for one quick
Oh,
second.
so you were setting him up.
This was.
No, I was not setting him up.
Yes, she
you set him
was.
up. No, you set him up with the whole celebrity roast thing. I do think
I put
this
him in
is
the middle.
thing.
It was an
This is
honorary
the
position.
thing- This is the thing that I think we have to grapple with, in addition to what Tiffany said, which is we have case after case after case, whether it's Dobbs, whether it's last year's case, effectively doing away with the line between church-state without saying it, doing away with Bakke and Grutter without saying it. Justice Thomas, in his dissent in the affirmative action case, goes, by the way, they just overturned it because, they didn't say it in the majority. It's not just the sort of cavalier batting away of precedent. It's not just taking cases where there's actually no standing. It's taking Moore v. Harper, having it become moot, and then say, it's not moot, we'll decide it anyway. It's taking 303 Creative, which is an entirely hypothetical set of facts about something that has not happened. And so I think you just have to look in the aggregate, not just to sort of whether or not these are
You're
big.
saying, why are they doing this?
I'm saying the way they are doing it is as consequential as what they're doing. And I think sort of limiting yourself to the end product and saying, well, they're saying they're not taking it any further. The same court that is telling you that precedent doesn't matter can't say, trust us next time.
And let me just point out, though, that in the student loan case, although there was an issue as to standing, the court's rationale was that the state of Missouri would be out $44 million in fees. So it wasn't a case where there was
Entirely
zero
without anybody having.
But it was also not the state of Missouri. It was an agency that was
the
separate
state.
from the state of Missouri. The state of Missouri was out zero. So, I mean, that's one of the things that, that's one of the powerful points in the dissent. Go ahead, Tiffany.
I was also going to say, realistically, Mohila wasn't going to be at a disadvantage. They had gotten new contracts from the federal government that were going to exceed what they were potentially going to lose from the cancellation of the student loans. So, I mean, Mohila was going to make money from their relationship. They weren't going to lose money. I mean, yes,
This
they were
is the
going to lose.
Mississippi entity that.
Yes, they were going to lose money from
Missouri,
the loan
sorry.
cancellation, but they had so much more money that was coming in from the federal government that Mohila was going to be on the upside. But the other thing that was so fascinating about that case, Mohila didn't even participate. I mean, Mohila was so uninterested in participating in this case that when the Missouri Attorney General came to them and asked for documents for the case, they said no. They forced the AG to use Missouri's Sunshine Law in order to get the documents. Mohila had no interest in helping Missouri sue the federal government. So I don't know.
Rod, I'm going to go back to one last preliminary thing, and then we'll get into some of the cases.
It's getting late to be still in the preliminary.
Yeah. It's a big year. It's very exciting. We are now hearing more and more about the shadow docket. Not everyone knows what it means. It does seem as if it's an end run, that it's an opportunity to get before the Supreme Court without there being a full slate of oral arguments and briefing, the full battery of things that happen there, and where you kind of get a decision about something without either. I don't even think they authored the decision, right? There's nobody's, their name isn't even.
Well, sometimes it's per curiam.
So sometimes, we're told that this is a dangerous new precedent, but I just want to say, when I look at this, I think it's come up twice already recently where the transgender girl who's on the cross-country team, that they allowed her to continue to, while her case is working through appeal, saying, if it's as sinister as it appears, you would have thought, for instance, the abortion pill in Texas, the court you'd think the conservative court would have said, that's right, let's go with that Texas judge and let's outlaw the abortion pill. That's not what happened. They used the shadow docket to protect the use of the abortion pill in Texas while that case is going through. Right. And the transgender student is still running cross-country, and you would have thought that a conservative court would have said, get her off that team. She's a man. right? You would have thought that's not what happened. So I'm wondering, are we hearing this thing as a Fox News problem about the shadow docket, or is this something is very unique? Bill, maybe you can weigh in. How unique is this to the court? It's something we really need to worry about.
Now, I think I'm interested in Adam's thoughts about this too. The term is somewhat pejorative, shadow docket, but there's nothing nefarious or sinister about what the court is doing.
Exactly.
The legal process sometimes can take a very long time, and there are legitimate reasons why you want to get to a decision
It's an
quicker.
emergency
Yes,
petition,
exactly.
right? It's basically what it is. It's an emergency. We go to the court on an emergency. Donald Trump used to do it all the time, right? He was constantly bringing cases on emergency petition, and they rejected. Adam or Bill, do you have something on this?
It's a big, complicated topic, but I think Amy Coney Barrett made a good point in one of the COVID emergency application cases. Just as it's very hard to get the court to take a real case, a merits case, you got about a 1 in 100 shot, it should be extraordinarily hard, even harder perhaps, in this special setting where you race up to the court on a moment's notice, on thin briefing, with no arguments, and then you get an order a week later deciding something very consequential. And Justice Barrett said, just as our cert process, is our process for deciding when to grant a petition seeking review on the merits, is very difficult, we should ordinarily stay out of stuff, and that makes sense to me. And I think they're a little chastened and doing a little bit better on that.
Let's start with the affirmative action case. We've touched upon it. Now let's get into some of these. So I have two thoughts. One is, in the minority opinion, Sotomayor makes a strong point that she doesn't say this is the end of the world, but she kind of says it's the end of the world. We were told, or we were reminded, that in the earlier run-up, there were a number of affirmative action cases that sort of started chipping away on 14th Amendment equal protection grounds at the idea of pure racial preferences. And it stopped at something called, what Rod said, the factor, that it could be used as a factor, just like hockey, or if your parents went to school here, that's a factor. Why can't race be just one of those factors? And the court essentially is saying, no, it can't, because if it's 14th Amendment, it's got to be colorblind.
Standing alone.
It's right. It's not like hockey, because hockey is hockey. This is something else. Skin color is a 14th Amendment equal protection argument. But Justice O'Connor, who we've already now mentioned was a swing vote many times, apparently in an earlier case, I can't remember if it was Michigan or Texas, I can't remember one where she said, in 25 years, we probably won't need this anymore. So that was like 23 years ago. So I'm wondering, is there a way to back off and say, maybe this isn't the worst thing? Or we have two educators on this stage. Is this something that, do you worry about this at Georgetown? Do you worry about this at Touro?
Yeah, no, I worry about it a great deal. I think actually Georgetown submitted an amicus brief in the case, and we focused on the Jesuit and Catholic mission, which was really about giving people a shot and opening up doors, and that this prevents us from doing that, right? And then and the other thing just to think about that's different from Dobbs. To some extent, it didn't work out that way, but the majority was saying in Dobbs, this is a controversial issue, let the states decide, right? With the affirmative action cases, it's a controversial issue, we will decide. So California has, under the prior regime, California could say no to affirmative action, but New York could say yes. Now everybody's got to say no.
Right. So the consequences of that
are huge. Now, so two other things. I think the point, so this is an example, though, of Chief Justice Roberts being an institutionalist, right? I think if Thomas had written the majority opinion, it would have been very different, right? So first of all, he would have very clearly struck down Grutter. So Grutter is the 23-year-old
right.
decision that says, in Michigan, you can consider race as a factor. Thomas clearly would have struck it down, said that that's invalid. And he basically says it, not just basically, he says it in the concurrence, right? And then, the other thing that I think is very significant is, what Roberts says at the end, and whether it's a response to Justice Jackson or, which I think it is probably in part because it's so laser focused on it, but I think it's also a sense in which he's trying to say, race can't be a factor, but we're also not going to make it totally irrelevant. And then, what that last paragraph means. So what he says is, race can't be a factor, but you can say, we'd like to see an essay about the challenges that you've overcome in your life. And if some of the challenges you overcome are that you've been a victim of racial discrimination, that's an okay factor to consider. So again, I think that that is, some opening that, everybody will be trying to figure out how big an opening it is, and there'll be a lot of litigation. But again, I think it reflects the fact, partly Justice Jackson's raising that issue, but also the institutionalist of Chief Justice Roberts.
So I have a couple of thoughts. I have a lot of thoughts, which I will not share all of them because of the time. So first, Toro, I would say that at the law school, so we are not an elite school. The law school is not an elite school like Georgetown, and where affirmative action in higher education really, really is relevant is in the elite schools. But I will say that I would imagine, I'm not at our medical school, but I would imagine that it's probably relevant at our medical school. And, there is evidence that if you don't have diversity within the medical profession, that it can have very negative effects within minority communities, especially when you don't have minority physicians who people trust. And so that is something that I am extremely concerned about as a consequence of this decision. So that is something that I have been thinking about. Something else that I've been thinking about too, though, when you ask the question, is it really that big of a deal? I think about what people are calling the diversity trap. And this just goes back to Bakke. The fact that we weren't allowed to tell the truth. Affirmative action is not about diversity. It's a remedial program. And it was always a remedial program. But we weren't allowed to be honest about that. And it's a remedial program that is supposed to deal with the fact that, I know people disagree with this, but I believe this, systemic racism is real. It continues to have impacts in the United States, and an affirmative action is a policy that is meant to address that. And when you think about affirmative action and systemic racism in that way, you cannot necessarily identify specific wrongs that your individual institution may have committed, but your individual institution exists within a context, the context of historical practices that have existed in the United States. And so, having affirmative action in your institution, just really quickly, it matters within that setting. And so these are some of the things that I think about as negative outcomes from having this decision. So I'm unhappy in a lot of different ways.
I just want to give you an anecdote. Goes back to an event we did here on this stage with Sonia Sotomayor. Because when you say the word remedial and you talk about elite schools, I'm not sure everyone understands what you mean, which is it really plays a role in creating integration within elite schools. And Sotomayor, when we had her that night, she had just written a memoir. If you read the book, it's a really great memoir. And she talks about how when she went to Princeton, she was in the first or second affirmative action class at Princeton. And she grew up in a housing project in the Bronx. She could not have been less prepared for what was waiting her. She jokingly says in the book, "I wrote like my mother spoke English." That was her line. She goes, "That's how I was writing English." And some English teacher took her under, and she was pushed, driven, to succeed. But it is interesting when you think about remedial, well, what does that mean, right? Because there was something in the Wall Street Journal just the other day about someone, I think from the Manhattan Institute, wrote about if it's really remedial, what you really want to do is strengthen not the elite schools, but strengthen the other schools, right? And so instead of people who may not be ready to be a physicist at Caltech, but if they were to Georgia Tech, they would become that physicist, right? So this is a whole new level.
Actually, Georgia Tech is very good. And so I don't, there are
I
any
knew I
Georgia
stepped
Tech
into that.
graduates out there.
I just was playing with the tech. Is Virginia Tech good? Just help me out. I just think this, I have heard this argument
It's a good
before.
thing we're not in Atlanta.
Yeah. Well, no, I mean, Thurgood Marshall went to Howard. one of America's truly great lawyer jurists went to Howard. Are we better off? Would we have been better off if he had gone to Harvard than Howard?
Well, at the time, Howard was extraordinary because of Jim Crow.
I see, good point.
And just, the other slight fly in the ointment here, in addition to the little loophole left for, you can tell us in your essay about your racial background if you do it with your mind, which is that, we don't know what that's going to look like, but you can do it. Best of luck. There's the carve-out for military schools. And the carve-out for military schools does not get explained. The Chief Justice says none of this applies to military academies, but I'm not telling you why, which raises kind of the question,
wow,
if the pipeline to the military needs to be diverse for all sorts of important unarticulated reasons, it would be an answer to your question about why.
Awesome,
And
great answer.
also, with that, you can talk about it in the essay. Number one, you're going to have a situation where guidance counselors in very sophisticated schools, sophisticated guidance counselors, they're the ones who are going to tell the kids, okay, this is how you craft the essays. But in the schools where the guidance counselors aren't that great, they're not going to convey that message. But two, what you're doing is you're setting up a situation where kids who are in pain have to turn their pain into a performance, and it's not going to be okay.
All right. I'm gonna quickly get through two cases just to give you a sense of things, and we're gonna move on to something else. I want to go back to the student debt case, and I want to do the EPA Clean Water Act case. Because what those things seem to have in common, and I know that we have questions, Tiffany, for sure, and Dahlia, like, how the hell does these cases even get here? But it does seem to raise this idea of what's called the major questions doctrine. And I just want the audience to know what we're talking about. Because what happens in that situation is the court says there's something called the major questions doctrine. If something has enormous political or economic impact, that it's really something that Congress should do. We would defer to Congress for and again, we have Bill Traynor here on the stage who can help us through this. What did the founders care about more? Did they care about judges making decisions, or did they believe in representative democracy? Did they want the local elected officials to make more of the decisions? So in the EPA case, the question becomes, do we trust the executive branch and all the PhDs in the EPA? Right? Do we really? Normally we think, of course you trust the EPA. But in the last 2 years, what we're seeing the court is to say, no, we don't have to trust the EPA. And similar in the student loan case, I think it also is a major questions doctrine. It says Congress has power over the purse. Congress is in the money business, the allocation business. This is $400 billion. President Biden has no business canceling the debt based on a statute from 2001, a 9/11 statute for getting people to go serve in Iraq and Afghanistan. He can't use that emergency and treat it as if the pandemic is the same thing. And so those cases were essentially decided. I don't want anyone to add to it. I'd rather skip on to the next thing. I just want people to know, the audience to know, those are where that's what's important about those cases, at least I think.
Yeah, the big question is...
This is where he says, never listen to things.
Now, the big question is, the conservative wing on the court wants to end the administrative state. So, that's the common theme. So, whether it's the Secretary of Education saying certain people pay less in student loans, or the administrators at the EPA saying what counts as a waterway, and last year with the EPA decision, right? That's the common theme, that they are using the major questions doctrine to say, the administrators, you can't do this. So
It's about separation of powers.
it's about separation of powers because it's a question of who makes the decision, right? Is it the president or is it the court, right? So this
or
is,
the Congress.
But there's a trick in here.
No, it's not the Congress. The Congress is worth do the student. Sorry. I'm getting a little
This is a
agitated.
pocketbook issue for him.
I love how excited you are.
I've
This is
never
awesome.
seen Dean Traynor
Now,
so animated.
The student
You gotta
loan
love
case,
this guy.
The student
Go
loan
do
case,
this.
Congress's text is clear. Congress's text is clear, and they're saying, and this is, Kagan is
Well,
totally right.
it's not
This
clear
is
that's
the
what
gift.
they meant, that you could just wipe out all debt.
What does waive mean?
Waive or modify.
Waive or modify means waive or modify.
Everybody's debt 100% across the board?
You know, it's the federal government's debt. You know, so yes, waive or modify means it's trusting the Secretary of Education to make a decision rather than the court coming and saying, we know
Or the
way
Congress.
democracy.
I mean, there's an option of Congress.
Congress,
doing it, right?
again, the text is Congress's.
But it wouldn't do it today.
What?
Congress today wouldn't vote for it. That's the
They
problem.
did,
that the
you know,
president
this is the
faced.
way it works. When a statute is passed, it stays, right?
No, but wait, but what, no, but seriously, I think, Rod, are you saying there's legislative purpose? We did this because it was a post 9/11 remedy. We didn't pass this statute thinking there was a pandemic.
If Congress had said in the statute, in the HEROES Act, if Congress had said you have the authority to waive all debt, then there wouldn't have been a case. It would have been a clear delegation.
They made the HEROES Act permanent in 2007, correct? It wasn't
I thought
just
it was 2003, but.
2003.
And they expanded it to emergencies. along
HEROES
the way.
Act is 2003. I think that in 2007 they said this is now the law. It
But-
was not just about
But
9/11.
what does happen in history? If something has a name like the HEROES Act, can you actually say, well, yeah, but it kind of applies in this
Well, they
case?
did apply it to
Right.
suspend repayment during the emergency.
Sorry, go
Can
ahead.
I try to harmonize these positions?
Great.
Try.
No.
I think Rod is right that ordinarily Congress should make these judgments. And I think the court is right to say Congress should make these judgments, but it's a very cynical thing to say because they know that this Congress is incapable of doing anything, meaning that the court ultimately makes the decision.
But I would say Congress has already decided. They chose the word waive, right? And so waive or modify. You're just applying what the text of the Constitution, of the statute.
Does everyone know what Bill's talking about? The question was cancellation. Is cancellation waive, right? That's what really we're talking about, because people have made this argument that wasn't what the statute never said you can forgive, you can postpone it, right? Isn't that what people are saying about this, or no?
I mean, I think.
Why are you focusing on waive?
Because waive means get rid of it,
I see, okay.
right? And, you know, and that's.
Waive means whatever the Education Department wants it to mean.
No, waive means waive. No, I mean, these textualists really should look at the text. And waive or modify gives really unlimited power to
Well,
the Secretary of Education.
that's exactly what the court concluded, that it wouldn't be reasonable for Congress to give unlimited power if they don't do it expressly.
All right, I'm going to move on. I'm definitely moving on.
No,
That
but
was a good
you know,
time.
I mean, but what they're really saying is, this is the text that they have, but they could not have meant what this text says.
Well, Nancy Pelosi agreed with the court on this issue.
Yeah, Nancy Pelosi does say, you know,
Rod, I think you're reading a super clarity requirement into this statute, and I don't know that that's fair.
Well, that's essentially what the major questions doctrine does. If it's something that's going to have tremendous impact, political or economic, the court has said that Congress needs to be clear in the delegation. So that's why I say it's really a separation of powers issue. The court doesn't care if Congress waives loans. Congress can do it. They just need to be express about
right.
it.
Now, one final thing is, when Congress creates a statute, when Congress passes a statute, they do it with a background understanding of what the Supreme Court case law is. When Congress passed the HEROES Act, Chevron was totally dominant. Chevron basically says if an administrative agency says something, we're going to defer to them, right? So Congress passes this statute, adopts this text at a time in which the Supreme Court has said, we, Supreme Court, will defer to what administrative agencies say. Congress passes the statute, and right now what the court is saying is, oh, no, we're not going to defer. We're going to create the major questions doctrine. We're going to totally second guess. So if you are going to interpret statutes, you have to take seriously the framework in which Congress passed the statute.
All right. Rod, I'm going to come back to you now. You spent basically the entire war on terror in the Justice Department or working as a U.S. attorney.
Well, most of it. I'm not sure it's over yet.
Yeah, right. Well, okay. All right, well, then this is perfect for you. I I have to say, am I the only one who was shocked that the two internet cases that dealt with the counter and terrorism, in neither case they were both decided 9-0? When you're talking about unanimous decision, there were two cases that were very similar. One, you can almost identify. A family sent their child over to Paris to study abroad. That happens all the time. ISIS committed a terrorist attack, and the daughter never came back. She was killed. The parent said, we are definitely suing Google. We are suing Facebook. We are suing all social media platforms, internet platforms, because we know that Tsarnaev brothers, who planted the Boston Marathon, we know that's how they learn how to make bombs. They watch the stuff on YouTube, and we are holding them responsible under counterterrorism, and we think that we should modify Section 230 of the Communications Decency Act. I can't believe that with this purportedly Supreme Court, you would have thought that they would have been all over Google and Facebook and social media. Instead, in both instances, they ruled 9-0 in favor of the social media platforms.
Right. It's a good example of a case where there was unanimous agreement. Justice Thomas actually wrote the opinion. There were two cases, one involving Twitter, one involving Google. And the basis for the court's ruling was that the allegation was that the social media networks were facilitating terrorism because the terrorist organizations spread the word through social media. And the court's ruling was there basically wasn't enough of a nexus. You can't hold the media companies accountable for the terrorist
They're not
acts.
aiding and abetting.
Correct.
Right. Okay. I just thought we should know that case. All right. Let's go back to something. We got Bill so hot a moment ago. Let's get him back. So Bill Traynor in the North Carolina gerrymandering case, which to me, I thought it was like the most important case. It was what, 5-4? It was a 5-4 decision or 6-3? Can't remember what was the result. The Harper versus Moore.
6-3, I believe.
6-3.
Kavanaugh concurred.
So I thought that was the most important case of the year because I thought, well, wait a minute. This just has everything to do with all the people that were questioning the Trump election we're talking about. Because I thought, well, this is going to get people all excited. People that are questioning elections said that the election clause in the Constitution says that when it comes to federal elections, the state legislature gets to set the rules for time, place, and manner. That's it. And so the conservatives were saying that's called the independent state legislature theory. That means no one interferes in election rules other than the state legislature. Now, if you remember, in 2019, we had a pandemic, and lots of rules got changed. Everybody voted by mail, absentee. Before that, only expatriates and military personnel. Instead, you had tens and tens of millions of people voting by mail. So then, of course, there were all these questions about the elections. You know, Donald Trump was spreading misinformation about fraud, but there were questions, right? So the one issue that I thought was coming up was saying, well, this just shows that those rules should never have been changed because state election officials and courts don't have the right under the Constitution. Bill Traynor, you should know, submitted an amicus brief in that case, and his early law review articles were cited twice in the Supreme Court's majority opinion. That's a huge achievement. I think that, yeah. So obviously, and he'll hopefully do this quickly, but obviously he believes that there's no such thing as an independent state legislature doctrine that means that there's no judicial review. It's crazy to think that the founding fathers didn't believe that a court could review the decisions made by the legislature. Is that?
Right. So there are two clauses in the Constitution that talk about state legislatures. One says states legislatures essentially can establish rules for election of congressmen and senators. And another says that they can establish the rules for the electors for presidential elections, right? So it matters for two reasons. One is the one on Congress really, can you gerrymander without a state court saying you violated the state constitution, which was really the Moore versus Harper question. In the 2024 election, and we saw it also in 2020, it also goes to, how free is the state legislature in establishing the rules for determining electors. So this was a big
You're saying
case.
let's not ignore the electoral college.
Right.
You're saying this is even bigger than what I'm talking about.
Right, so it's not just the
Right.
gerrymandering, it's also what it would mean for the 2024 election. So big, big issue. And the independent state legislature theory is when it says state legislatures make the decision, that's what it means, period, right? And my dissertation was basically said judicial review was established at the time of the founding. It was not Marbury, it was before Marbury. And so when they say state legislatures, they mean state legislatures as created by state constitutions, which means the state court gets to say, you know, the gerrymandering, it violates the state constitution, right? And that's the way Chief Justice Roberts came down. Big, big decision. Two things, you know, one is I was surprised. You know, the Alabama case surprised me, and this case surprised me. And, you know, so the Solicitor General's office, it frankly, there's a good argument that it was moot, because there was a kind of a decision by the North Carolina Supreme Court.
There's a new
that was under
court.
review, and then there's a new court
Right.
that all of a sudden is a Republican court, and they say, never mind. You know, forget what the Democratic Supreme Court said. We can't consider this. But I think Chief Justice Roberts wanted to hear this case because he wanted to prove that he was an institutionalist and that the court was not going to ram through stuff that was not good for democracy.
I see.
So, but the Solicitor General said, this is moot, because it looked like there were at least 4 votes in favor of the independent state legislature theory, and I was worried that there were 6.
And this is going to have a huge impact on this next election, right? Because for those people who would say, remember, Republicans control most state houses, especially in battleground states. So think about the implications here. If the state legislature is the only ones that can establish what the rules are, and they happen to be Republican, this is essentially saying, but not without judicial review. If you're getting CLE credit, here's your second bingo number. LOT L8. LOT, T as in Thomas, L8. All right, I want to move now to the Colorado case, because a number of years ago we were all here. I can't remember which one of you were here that day. That was the Master Bake case. That case, we never got that case resolved. This case about the web designer in the same state of Colorado, where a master baker said, look, I do not believe in same-sex marriage, and you're telling me I violate the anti-discrimination laws. I'm not just any baker, I'm the master baker, and you can't force me to bake a cake in something I don't approve of. And this woman, in this new case, is saying, I am a really good website builder. I'm excellent. And I would like to get into the business of marriages. But I don't want to be in a position to be in violation of Colorado's anti-discrimination laws. Let me tell you something right now. There is no way I'm making a website for same-sex marriage. And that's what this case was about. Now, I have a few questions for you. The first thing is, the Supreme Court apparently took part of the First Amendment off the table. They said, we're not interested in hearing about your religious feelings. We are only interested in your free speech expressive rights as an artist. We're not interested in you telling us this is not what Jesus Christ told me. So first of all, why did they do that? Why didn't they just make it easier? If the conservative court could have made it even easier for themselves and could have said, you know, you have a religious right to not make this cake or this website, and you have a free speech right not to.
Because it was easier. Colorado stipulated to all of the speech claims. I mean, this case really is a model of bad lawyering. The lawyers for Colorado gave away the case.
There's a second reason. To do the religion piece of it, they'd have to overrule a major precedent, which they'll do soon enough, but they're not going to do it in this case.
And maybe the third reason is that last year they took 2 big religion cases and made big swings in those religion cases. So if you can do this as a compelled speech case and not and graph the other
I love
religion, I think it's just a way to turn down the temperature. And as Adam says, those religion cases are not going away.
And just for remembering, for those of you who were here and may not remember, I think Dahlia's talking about at least 2 out of 3. One was the football coach who wanted to say a prayer after the game on the 50-yard line, and they ruled in his favor. One was a Catholic adoption agency in Philadelphia, right? And then there was the Maine private school. There was a Catholic and said, well, we don't want to do adoptions in a same-sex marriage. We're a Catholic adoption agency, and they basically said, you know what, there are plenty of adoption agencies in Philadelphia. We can't make you do it. You have to a same-sex couple needs to go somewhere else. So Dahlia is saying this was just very radioactive. And also, I wonder whether you would say, all of you would say, we are and I've written a book about this, I think we're a crazy free speech country, right? When it comes to other Western democracies, we're out of our minds. We do things that no normal country would do. Nazis get to march on a town of Holocaust survivors, burning crosses on the lawns of African Americans. This is nuts. Destroying the funeral of a serviceman because you wanted to protest gays serving in the military. No Western democracy would put up with any of this nonsense. We do it. And so one question would be, maybe the court said, you know, just go back to what we do. What we do is we always grant very, very expansive free speech protections. And if this woman wants to say, I'm an artist, maker of websites, that she has the right to say, I have a free speech right to do what I want to make the art. And I think the court said something about expressive, right? That if you make something, right? Because I think I just read, did you write about this in today's paper, about this new case that's coming up, that might come up with firing a substitute teacher who is married to a man?
Yeah, I think that's a different line of doctrine, but you're right to say that it's not every business. The tire store, the Walmart still can't discriminate against people based on sexuality.
Two guys holding hands in a 7-Eleven want to buy a pack of cigarettes. You can't stop.
Right.
You can't say, I'm
so
not
it
selling
applies.
you.
It applies to this category, hard to define, expressive businesses, you know, songwriters, painters, and who make their work on a custom basis. So none of that makes, you know, the people who are being discriminated against any more comfortable, but it is a narrower class of businesses than you would first think.
But it also, so the two things that are the hard issues, which Gorsuch doesn't go to, are one is what becomes expressive, right? I mean, he says this is expressive, but how far do you push that, right? Somebody was, people are talking now that Subway is saying our sandwich makers are artists. I mean, how far do you, what's the dividing line, right? And then the other is, why is this different from race or religion, right? And and he doesn't, that's
You're saying
the
it
hardest.
shouldn't be.
Well, that's the big question, and he doesn't touch it, right? I mean, if the web designer had said, I'm not comfortable making a web wedding announcement for somebody who's Jewish, because I'm, deeply evangelical, and I just don't think that should be recognized, or I don't want to personally recognize that. Why is that different than this case?
And this is a great example from Justice Sotomayor. I'm a school photographer. I take pictures of students. And an interracial student comes up. I'm not going to take that picture because I don't believe in interracial marriage.
And I'm an artist. Right.
Well, I think a portrait photographer is pretty far down the spectrum in the direction of artist. And Gorsuch, don't you?
I vote for
that's
you.
speech, yeah.
And Gorsuch doesn't touch that. Doesn't have a good answer on race.
And maybe this is the answer to your framing question, which is this is a religion case that's cloaked as a speech case, because her objection is that it is a false marriage, right? And Gorsuch says that she shouldn't be forced to say this is a marriage if her faith holds that it's false. But what Sotomayor says in her dissent is, let's remember all those civil rights cases, right? From all the refusals of service were also rooted, some of them, in religious objections to serving people of color.
Yoke not unlike oxen.
Okay. I was also going to ask, I was going to wonder, you remember you said something about the student loan case earlier about, well, why is it even here? And I wondered whether you were going to jump in now and say, she hasn't made one website yet. She's not ready to, that you could make that same argument. This is a woman who says, I'd like to get into the marriage website business, but I don't want to be in a position where I violate the anti-discrimination law.
I think there's force to that. Sotomayor did nothing with that. And there is a First Amendment concept known as a pre-enforcement challenge, which if you have a credible fear of punishment, you don't have to violate the law to get punished for it.
You're saying that's a legitimate legal argument to say.
That is a mainstream legal argument.
Right, and so it's even bigger. Right, so that wouldn't have been a ripeness or standing issue. Before we take one question from the audience and say goodnight to everyone, since we're on the subject of religion, 9-0 for the postal worker? 9-0, back to religion. A postal worker doesn't want to, he's religious, doesn't want to deliver mail on Sundays. The Postal Service, as you know, is going out of business. And if not for Amazon, they will not survive. That means that they have to deliver mail on Sundays to help out Amazon. They said to this religious person, well, you got to work on Sundays. He's going, there's no way I'm doing that, right? Supreme Court takes this 9-0, essentially ruling in his favor under his religious liberty rights.
Well, on the statutory issue, he hasn't won yet. Mr. Groff has to go back to court, and he now has to prove, that his employer, the Postal Service, has to prove it would be an undue burden for them to accommodate him. So the case, which was written by Justice Alito, actually elevated the showing required by an employer who's denying an accommodation. There was an argument that it should be de minimis, and the court held instead you need to show an undue burden.
By the way, just so we have constitutional law professors and legal scholars, the Master Cake case that never actually got resolved, is it now resolved or not? Because he also, I think he made a First Amendment argument and a First Amendment freedom of religion, speech. And so what does he do now? Does he take this, right, here's a question. Is he tomorrow violating the statute by not making a cake?
Well, it's a question of how he frames his argument, and I think the interesting issue that this case may create is, what if his argument is, I don't mind making the cake, I understand I'm required to make a cake, but I shouldn't be required to put a picture of a homosexual couple on the top of the cake, because that's expressive. That's the case I think the court might have to confront next.
Cool. Very
Can
legalistic.
I just go back and follow up on, Rod, on your point? So are you saying that essentially Alito took a position which was not as pro-religion as he might have? In other words, is that what am I hearing?
In the sense that I think he made a decision about what he believed the statute required. The language in the statute is undue burden, and they were simply enforcing the statute.
Okay.
Question from the audience. We'll say goodnight. This was awesome, right? Don't you think? This was pretty good. Well done. I always say, no one leaves a Folks event stupider. It's just never happened. You always walk, it's something, a promise, we'll give you your money back. You come out of a Folks event, you're lightning on your feet. Has original intent become a pseudonym for conservatism? I think that this is an interesting question. We start to hear, originalism, terms of art, textualism. We hear this in the public sphere. These are legitimate legal concepts. They're not excuses in order to be a conservative.
So I would say two things, and actually Tiffany started us off on a very important point. So when I was in law school many years ago, originalism was actually a liberal doctrine. And people forget that, but there was a great book, Constitutional
What year
Faith.
was that?
1980. 1980. So, if you think about who the great originalist on the court was in the period we were talking about earlier, it was Hugo Black. He really brought originalism.
You're talking about the
to
Fortis Court? Is that why you're saying we're talking about earlier?
Well, the Warren Court.
Warren Court.
There was
okay.
no Fortis Court.
Exactly.
Right?
I'm just saying, when you said earlier, I want the audience to know what we're talking about.
So Hugo Black said the Bill of Rights applies to the states because I will read the 14th Amendment to incorporate the Bill of Rights. So during the Warren Court and the Burger Court, originalism was really much more a liberal position, right? Now, we've had a period starting with Ed Meese,
Reagan administration.
The Reagan administration, and Justice Scalia, in which people think of conservatism and originalism as kind of a Vulcan mind meld, right? But one of the interesting and important contributions that I think Justice Jackson is already making is that she is offering a progressive view of originalism.
Cool.
So we'll see over time how that plays out, but that's something that we really have not seen for decades.
Ladies and gentlemen, Adam Liptak, Tiffany Graham, Rod Rosenstein, Dahlia Lithwick, and Dean Bill Trainer. Good night. Good night. Thank you.
Is there a way to get down?